So we need to talk about a new case granted review by the Supreme Court that has now been set for oral arguments on October 15th. This case attempts to build off of a prior 9-0 unanimous decision by the Supreme Court, which impacts your rights to prevent the unlawful search and seizure of firearms within your home without a warrant. So let's break down what is happening in this critical case. Now, before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month. And right now, TacPack is doing something special for my viewers. The next TacPack Plus box that is going to be featured has a record amount of gear included in the box. They have brands like Battle Arms, 9line, and more other companies. And the September TacPack Plus box is going to be worth over $330. So anyone who uses my code ARMSCHOLAR and you sign up for the TacPack Plus subscription-based box, you're going to get that huge value in the September box, but also you'll get a free gift of a tactical gear box, which is also worth at least $70. So if you're interested, use my link down below and remember to use my code ARMED if it's your first time getting a subscription, because you will get that free additional $70 tactical gear box, and that will ship with your first subscription. So as I mentioned in the intro, in this video, we're going to be discussing a new Supreme Court case that was granted review, and this involves when police officers can enter someone's home without a warrant. This case tries to use a prior 9-0 unanimous decision issued by the Supreme Court, which involved the warrantless search and seizure of firearms within a home. This new challenge pending in front of the Supreme Court is called Case versus Montana. This new challenge is important for gun owners to understand and know about because it involves when law enforcement can use legal workarounds to not only enter your home without a warrant, but also potentially confiscate firearms without a warrant. Now, the facts surrounding this case are very interesting. Essentially, this lawsuit is a result from Trevor Case's ex-girlfriend who called police saying that he had threatened to harm himself and that he might also have a gun. She also told the police officers on the phone that Mr. Case had told her that if they showed up at the home, he would potentially also harm them. Apparently, also, all of these police officers knew Mr. Case. They knew he had a history of some mental health issues, and they had prior interactions with Mr. Case. When the 4 police officers arrived at the home, they looked through the windows, they looked into all the rooms, they did not see Mr. Case. They shined a light into some of those rooms. They saw that there was a handgun in a holster. It was unloaded. They also saw a notepad. They called for him through one of the open, windows. They, tried to knock on the door to get, in contact with him, but he did not answer. After about 40 minutes at the home, the police officers then decided to enter the home through the unlocked front door. Now, many of the police officers actually expressed concerns before doing that. They were concerned about entering the home because of prior interactions with Mr. Case and threats that he had made on the phone that maybe he actually wanted to engage with these police officers if they entered the home. There was also a short discussion between the police officers about, maybe trying to call his father to have the father come to the home to try to contact Mr. Case. And they also even mentioned trying to call Mr. Case on his cell phone. But ultimately, the police officers decided to not do any of that. Instead, they decided to grab their rifles, grab some ballistic shields, and then they entered through that front door, which was unlocked. One of the police officers entered a upstairs bedroom, and he saw that one of the closet curtains opened up. He said that it jerked open, and it revealed that Mr. Case was in there. And he also saw something what he said appeared to be a black object, which he took as a firearm. The police officer then responded by shooting Mr. Case once in the arm and once in the stomach. And they, gave him medical attention, called, for an ambulance. And then they also did a search of the house, and eventually they recovered a handgun in a laundry basket that was near Mr. Case. Mr. Case argued in response to this that the officer's warrantless entry into his home violated the Fourth Amendment, so the gun and other evidence that was found should actually be suppressed. Those arguments were ultimately rejected by the lower court, and eventually this was also, appealed up to the Montana Supreme Court, who, after a 4-3 split decision, sided with the state of Montana and said that that evidence should not be suppressed based on the warrantless entry into the home. This challenge has now made its way to the United States Supreme Court and was recently granted review. The question presented to the Supreme Court, which they will address, is whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception requires probable cause. In his petition, Mr. Case argues that while this court has recognized exceptions to the exigent circumstances, it has jealously and carefully drawn those exceptions. The court should take the same approach in defining the exigency exception to the emergency aid exception and hold that officials must have probable cause to believe an emergency actually exists before making a warrantless entry into a home. He goes on to argue that the Supreme Court rejected any freestanding community caretaking exception in the case Caniglia versus Strong. However, the Montana Supreme Court upheld the officer's warrantless entry into the home of Mr. Case on the basis of that whole community caretaking test, requiring only reasonable suspicion of an emergency. He states that that decision not only contravenes what Caniglia said, but more fundamentally adopts a less stringent standard of knowledge, something that is lower than probable cause. He states that there was no sort of emergency exception that was required here in this case, and there was also definitely no probable cause because the police officers sat outside of his home for over 40 minutes before they decided to enter the home. Mr. Case argued that the search was not justified under the community caretaking doctrine, which was also struck down in the Supreme Court's decision Caniglia versus Strong. Now, if you're not aware of what happened in that Caniglia case, essentially a husband and wife got into an argument, and during that argument, the husband actually responded by getting out one of his handguns, putting it on the table, and told his wife, "Why don't you just take it and put me out of my misery?" Now, of course, the wife was concerned about that activity, so she decided to leave for the night. She stayed at a hotel. The next morning, she tried to call her husband, and he didn't answer. She then called police officers, said that she was concerned about her husband. The wife and the police officers arrived at the home, and they found that Mr. Caniglia was actually on the front porch and nothing was wrong. However, in response, the police officers were concerned about Mr. Caniglia, so they decided to take him to the hospital for a psychiatric evaluation. Now, during the conversation between Mr. Caniglia and the police officers, he told them that he did not want them to take his guns. They said that, yes, they would not take any of his guns. However, once he left for the hospital, the police officers went to the wife and said that the husband actually told them that they could confiscate those firearms. And believing those police officers, the wife allowed them to enter the home and they gave up those guns. Because of that, this lawsuit then sprung up because of the warrantless entry into the home and the confiscation of those firearms. Now, eventually, this case made its way to the Supreme Court back in 2021. And on review, the Supreme Court issued a rare 9-0 unanimous decision in favor of Mr. Caniglia. The Supreme Court struck down the community caretaking rationale that was used to enter the home and to seize those firearms. Since that decision, the Supreme Court has not considered or, expanded upon that whole exception and what really is involved in these types of emergency aid exceptions, and they have not addressed any of these issues since 2021. It is the Caniglia decision and that whole issue of the community caretaking exception and these types of exigent emergency aid exceptions that is now being sought to be clarified in Case versus Montana. The Supreme Court now has an opportunity to clarify or expand upon that prior 9-0 unanimous decision by the Supreme Court in Caniglia, and that can have direct downstream implications on what protections we all have from police officers and the government from entering our homes without a warrant and potentially searching and even seizing our firearms without, a warrant or without our permission to enter the home. Like I mentioned, oral arguments are now happening in this case and they're set for October 15th. So this is something we're going to be looking forward to and watching closely to see, what type of questions does the Supreme Court actually ask during those arguments? What type of hypotheticals do they ask? And you can kind of get a good sense based on those questions about maybe how the Supreme Court is going to lean on this issue. So that's what's currently going on in the critical warrantless search and seizure challenge that is currently in front of the Supreme Court. As we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have the free legal guide that you guys can get. All you have to do is put in your email, and we email you over a free PDF. I will also leave a link to that down below in the detail section in the pinned comment. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.